Good evening and welcome to Landmark Cases. Tonight's case is Gideon versus Wainwright. 55 years ago this month, the Supreme Court ruled that the right to counsel was so fundamental to our governmental system that states must provide lawyers for defendants who cannot afford one. The hero of tonight's story is a bit of an unlikely one. Clarence Earl Gideon was a drifter in Florida who was accused of breaking into a pool hall. And as we begin tonight, we're going to go to some historic video. You'll see the real Mr. Gideon and the Florida judge who sent him to jail. They reenacted the case for a CBS News documentary in 1965. Let's watch.
The next case on the docket is the case of the state of Florida versus Clarence Earl Gideon. What says the state? Are you ready for trial?
The state is ready, Your Honor.
What says the defendant? Are you ready for trial?
I'm not ready, Your Honor.
Did you plead not guilty to this charge by reason of insanity?
No, sir.
Well, why aren't you ready?
I have no counsel.
Why do you not have counsel? Did you know that your case was set for trial today?
Yes, sir. I know my case was set for trial today.
Why then did you not secure counsel and be prepared to go to trial?
Your Honor, I request this court to appoint counsel to represent me in this trial.
Well, Mr. Gideon, I'm sorry, but I cannot appoint counsel to represent you in this case. Under the laws of the state of Florida, the only time the court can appoint counsel to represent a defendant is when that person is charged with a capital offense. I'm sorry, but I will have to deny your request to appoint counsel to defend you in this case.
The United States Supreme Court says I am entitled to be represented by counsel.
And let me introduce you to two guests who are at our table tonight. They return to us from season 1 of Landmark Cases. Paul Clement, former U.S. Solicitor General under President George W. Bush, 2004 to 2008. He's now a lawyer in private practice in Washington, D.C. at Kirkland & Ellis. He has the distinction of arguing more cases before the Supreme Court, 85 times than anyone in private practice. Thanks for being with us. Akil Reed Amar also returns to the table tonight. Glad to have you back, Professor Amar. He's a law professor at Yale and a visiting law professor at the University of Pennsylvania. He's the author of numerous books on constitutional law. His latest is called The Constitution Today, Timeless Lessons for the Issues of Our Era. So, Professor Amar, was Mr. Gideon at the time he said that correct? Did the Constitution guarantee him a right to counsel?
And he said the Supreme Court has said it, and the Supreme Court hadn't said it. It would in the case that he would eventually help get to the Supreme Court, which is what we'll talk about this evening. What the Supreme Court had said before is that federal defendants being prosecuted for federal crimes in federal court could have appointed counsel, but the court, in a case that people may not have heard of, is called Johnson versus Zerbst in 1938, but the court had never quite said that that was true for all non-capital cases, being non-death penalty cases being tried in every state court.
Mr. Gideon had that notion because of the Sixth Amendment to the Constitution, which says, in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial and to have the assistance of counsel for his defense. Paul Clement, he also turned to the 14th Amendment because he was really quite a student of the Constitution, which says, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Nor shall any state deprive any person of life, liberty, which he was about to be deprived of, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the law. So why did that entitle him to a lawyer?
Well, that again is the question that the Supreme Court would eventually decide, but I think that Mr. Gideon was actually quite right to focus on the Due Process Clause in addition to the Sixth Amendment, because one problem that he had is that the Sixth Amendment, by its terms, applies only to the federal government. It constrains the federal government, not the state governments. But the 14th Amendment and its Due Process Clause directly constrains the states. And so that's why he was quite right to point to the Due Process Clause as ultimately being the basis for why Florida, as opposed to the United States government, why Florida had to give him a lawyer.
So on Facebook tonight, I saw a criticism from someone who says a liberal case. Another C-SPAN's picking a liberal case tonight. Is there something about this case that both liberals and conservatives can find to like? Let me start with conservatives.
Well, I don't think of Gideon as being a left-right case. And as you say, I think there are things for everybody about this case. But I think particularly from a conservative, the idea that when somebody is facing the awesome power of the government, and the awesome power of the government is about to take away their life or their liberty, I mean, to be able to have the assistance of counsel and make that guarantee real, I think is something that conservatives, and I would think liberals, would value as a cherished right.
Akhil Amar?
So in the era since the Warren Court, what's very interesting is it's basically been a court in my entire adult lifetime where Democrat appointees have not been a majority on the court since 1970. And so it's been a Burger Court, a Rehnquist Court, a Roberts Court, Republican Chief Justices appointed by Republican presidents with a majority of members being Republican Party members. And the court might not like everything, the modern court might not like everything the Warren Court did, but Gideon is absolutely bedrock across the board, 9-0, and other things aren't. For example, the exclusionary rule, which comes out applied against the states at about the same time. Well, conservatives don't like that, and I might be with them on that. But we all believe, left, right, and center, in this bedrock right to have a lawyer. It's the right to have rights, because if you don't have a lawyer, you really can't defend any of your other rights. And even from a conservative point of view, if you're going to put people in prison because you actually believe in law and order, you want to put the people, in prison who actually did it, who are guilty, and that legitimizes the whole system. Is that you actually do have lawyers who can put the government to its proof to prove that these folks really are guilty of something, rather than guilty of simply being too poor to hire a lawyer.
And I think one of the great champions of the Sixth Amendment in recent years has been Justice Scalia. So I think that just underscores this is not a left-right issue.
This is a case with some interesting and some big characters, so we're going to tell you about them as we wade into our story. First is Clarence Earl Gideon himself. Anthony Lewis, the Pulitzer Prize-winning New York Times reporter, wrote a book that's a best-selling book about this case at the time called Gideon's Trumpet, later made into a movie. And here is how he describes Clarence Earl Gideon. Gideon was a 51-year-old white man who had been in and out of prisons much of his life. He had served time for 4 previous felonies, and he bore the physical marks of a destitute life. A wrinkled, prematurely aged face, a voice and hands that trembled, a frail body, white hair. He had never been a professional criminal or a man of violence. He just could seem to settle down to work, and so he had made his way by gambling and occasional thefts. Those who known him, even the men who had arrested him and those who were now his jailers, considered Gideon a perfectly harmless human being, rather likable, but one tossed aside by life. Can you add any more to the story of Clarence Gideon?
Well, Anthony Lewis really can write, and I think that's a very nice portrait. We're going to talk a lot about the man and the case. Truth be told, from a certain point of view, if Gideon hadn't been the vehicle or instrument for this Supreme Court ruling, I do believe that some other litigant would have been, because there are larger structural forces at play in the development of the United States Supreme Court's case law that made this the right time for the court. The court was looking for a case like this one, so that's the other thing I would emphasize.
We're going to hear about Earl Warren, Chief Justice of the United States. Tell me briefly who he was.
Well, Chief Justice Warren is an incredibly large figure in Supreme Court history, and he's the embodiment of the Warren Court. I mean, he's also the embodiment at one level of what a Chief Justice should look like. He looked like a judge should look, and he had a very personal presence. He had come from California, had been the governor of California, so he had an experience, a career before he came to the Supreme Court. But what he's probably best known for is leading the Warren Court and the Warren Court's revolution in criminal justice procedure, of which Gideon is an important component.
And he's a Republican. He ran for the vice presidency of the United States on the Republican Party ticket in 1948. If Dewey had defeated Truman, then Earl Warren would have been the Republican vice president. He's put on the court by a Republican president, Dwight Eisenhower. This is to the earlier point about whether this is just a liberal case. The other justice that I would mention, who's going to play a very big role, I think, in our conversation, is Hugo Black himself, a very interesting character. He's going to write the majority opinion in the Gideon case. Earl Warren is going to assign the opinion to Hugo Black, and Hugo Black is someone who had been a lawyer in private practice and had defended all sorts of people, from indigents, from poor people, to wealthier clients.
We're also going to hear the name Abe Fortas. Who is he?
Abe Fortas comes into this drama not as a Supreme Court justice, though he will later be a Supreme Court justice and then a failed nominee for the Chief Justiceship. But here it's Abe Fortas, the lawyer. And at the time that he is appointed to represent Gideon, he is at the top of the legal profession. He's one of these great Washington fixers and great lawyers of the time. And he ends up, Clarence Gideon goes from not having any lawyer to having one of the great lawyers in the country in the Supreme Court of the United States.
Across from him was a person by the name of Bruce Jacob. You know anything about him?
Only what I read from Anthony Lewis's book, but I think we're going to see him maybe in the course of the evening.
Right. He argued 2 cases before the Supreme Court, and a really interesting history about both of them, and we'll learn about that later. And then the other namesake, Wainwright. Louis Wainwright, he really has very little role to play in this case. He was the head of the Florida prisons. How are those names assigned to cases?
Well, they're assigned to cases in the first instance based on which party is sued in the action. And the reason that this is Wainwright as opposed to the state of Florida is this gets to the Supreme Court in a habeas petition as opposed to a direct appeal. And so when you file a petition for writ of habeas corpus, it's really you sue your jailer. And that's why the head of the Florida prison system was the defendant. Of course, Wainwright really is a pretty small player in this drama, because when the case is first filed in the Supreme Court, there's a different head of the agency, and it's just an official title, and they just swap them out one after the other, but Wainwright's the one that stays in the caption of the case that we all know.
Earned his way into history by not even being around for the case. We love to have your participation in this program, and in about 10 more minutes or so, we'll be going to your phone calls from across the country. Eastern and Central time zones, 202-748-8901. If you live in the Mountain or Pacific time zones, 202-748-8901. You can also tweet us, use the hashtag Landmark Cases, or you can go to C-SPAN's Facebook page and you'll see a posting about tonight's case and already a conversation underway. Well, we're going to go back to some video, and we're going to take a look at how Clarence Gideon ended up facing criminal charges in Panama City, Florida.
It was on Saturday, I believe, when I was arrested, and I was arranged officially on Monday morning, and they give me a preliminary trial the next day on Tuesday. And that was the first time that I found out the actual direct evidence they had against me of breaking into this place here.
This is the file folder for the Gideon case. We keep that separate from all our case files now because of all the interest we have in the case and the historical value of it. The original case file. Some of that, since it is getting so old, it's really hard to read. This is the charging document from the state's attorney's office from 1961 when he was charged with breaking and entering in the bar or the pool room. Real brief summary. They're saying there's that Mr. Gideon did in fact break into the pool room and he stole money or property. This one is actually the verdict sheet finding Mr. Gideon guilty. So the defendant was sent to state prison on September 7th, 1961, and for a term of 5 years.
Even though Panama City was on the losing side in this case, they've really become part of history. So it's really interesting and fun to see how that local city in Florida has preserved all of the papers for this case and has a bit of a museum that preserves their place in history. So explain why Judge Robert McCrary, whom we saw in the video earlier, when you watch more of this, you actually see he's trying to help Clarence Gideon along, but the law doesn't only allows him to go so far. What would Florida law allow at that point, and was Florida unique in not having assigned judges for indigent defendants?
So Florida law at the time only allowed for the appointment of counsel in a narrow band of cases, principally capital cases or death penalty cases. They weren't alone at that time in not providing counsel to indigent defendants, to poor defendants, but they were in the minority at that point, and the trend of history was clearly going against them. So I'm not sure about the precise number, but I think you were down to about a dozen jurisdictions that didn't provide counsel in all cases to poor defendants.
It was even more dramatic than that. So two things. One, yeah, the judge is trying to help Gideon out a little bit, but it's very difficult to be a coach and the umpire. And some folks who say, gee, the Constitution doesn't say appointed counsel. It's true, and at the founding, actually, the framers only provided for appointed counsel in death penalty cases, but in the other cases, the judge was actually supposed to help the defendant, but as time went on, it became clear that you couldn't play these two roles. So one argument for the rightness of the case is just judges can't be effectively coaches and umpires. But a second argument is, actually, as Paul said, the trend of history had very strongly moved in a direction. By the time of the Gideon case, only 5 states were not giving appointed counsel in all felony cases, and even among those 5, and they were all in the former Confederacy, and Florida was one of those 5, but even then in some of the big cities, appointed counsel was being offered, always in capital cases. And what the judge also said, he says, gee, I can't do it. No, he wasn't required to do it under Florida law, but even judges who weren't required to do it often were choosing to do it. And from a states' rights perspective, here's an amazing fact about the case. 25 states actually weigh in with amicus briefs on one side or the other, friend of the court briefs. 22 of them, led by the then Attorney General of Minnesota, Walter Mondale, 22 side with Gideon, and only 2 join Florida, saying we shouldn't be forced to do this.
But Mr. Gideon's case went to the Florida Supreme Court. Did they have really any choice but to uphold the conviction based on the laws of the state?
Well, based on the laws of the state, the statutory laws of the state, I don't think they really had much choice. I think it probably would have been open to them to decide a right under the state constitution, but I don't think there was much of an appetite for that. And unlike the Supreme Court, the Florida Supreme Court didn't pick Clarence Gideon's case as a vehicle to make a change in the law. And so from the perspective of the Florida Supreme Court, this was just another case, just another prisoner with really not a valid claim in their eyes. And so, I think when you get to the way the Supreme Court of the United States treats this petition, it's night and day compared to the Florida Supreme Court that just sees this as another hopeless petition.
And other Supreme Courts at the time were recognizing counsel rights even when the state constitution wasn't entirely clear, even when state statutes didn't provide for it. As a matter of administration of justice, courts in other states, state courts, are saying, we're kind of in charge of the justice system in our state, and we're going to improvise in some ways, because even if the United States Supreme Court hasn't yet required us to do so, think about it this way. If the Supreme Court ever does require us to do this, are we going to have to go back and redo all these convictions? And for our own purposes, do we ever want to be convicting people who might be innocent just because they don't have good lawyers? So other states, other than Florida, the state Supreme Courts were more forward-leaning than the Florida Supreme Court.
And you mentioned one earlier case. Would you also talk about Betts versus Brady in 1942, which was the last time before this case that the Supreme Court had ruled on the right to counsel?
So I mentioned Hugo Black, who was himself a very interesting character, a Southerner, former senator from Alabama, the way Jeff Sessions would be today, and he is he doesn't come from any fancy family background, a hard-working Alabama family, doesn't go to 3 years of law school even, but he pulls himself by his own bootstrap and gets himself elected to the Senate, and he's Franklin Roosevelt's first appointee to the United States Supreme Court after Roosevelt's re-election in 1936. And he writes in 1938, maybe his first big opinion, saying the Sixth Amendment requires that the federal government give appointed counsel to a federal defendant. And then in this next case, in Betts versus Brady, which you mentioned 4 years later, the question is, what about the states? And Hugo Black is in dissent in that case. He thinks that the Bill of Rights, which originally applied only against the federal government, should also apply against the states. It's a famous theory. It's called incorporation of the Bill of Rights. The Bill of Rights, on Hugo Black's view, is incorporated against the states. It begins, Congress shall make no law, but he thinks that the 14th Amendment, no state shall make or enforce any law which shall abridge, applies all these rights: speech, press, petition, assembly, counsel, due process, double jeopardy, speedy trial, public trial. He thinks all these rights apply against states, does Hugo Black. And the first case where he says it, and it's in dissent, is Betts versus Brady. And then later on, in 1963, he finally has a chance to take that dissent and turn it into a majority opinion. And he does.
So Clarence Earl Gideon goes to jail, sentenced to 5 years for what seems to us like pretty small crimes. He took some wine, he took some beer. If he was in fact guilty, which he says he was not. What was also missing was some change from the jukebox and from the cigarette machine, and sentenced to 5 years. Now, we said earlier that this was a man with an 8th grade education, but he had been studying the Constitution since school. And what did he do when he got to jail?
Well, when he got to jail, I mean, he started the process of becoming a pretty good jailhouse lawyer. And one of the things that he did, and the professor made the point earlier, that in some respects it's a little bit of an accident of history that Clarence Gideon is the person who gave us this constitutional right. If the Supreme Court had been ready at the time of Betts v. Brady, we'd be talking about Smith Betts as the person who brought us this constitutional right. But he gets lucky in a sense, but he was also smart. I mean, if he hadn't preserved his request for right to counsel, then his case might not have been the vehicle. And if he hadn't understood that he had the right to file a habeas petition and had a right to take his case all the way to the Supreme Court, then we wouldn't have Gideon against Wainwright. We might still have the right to counsel in a different case, but it wouldn't be Gideon's case.
Clarence Gideon wrote a letter to the Supreme Court, and it was one of many such appeals that the court receives every year. You're seeing what it looks like, handwritten with pencil. And we're going to listen to Arthur Goldberg, a justice of the Supreme Court, about how the justices deal with these kinds of petitions when they get them at the court. Let's listen.
What happened when the court received the Gideon letter?
When a letter is written to us from a prisoner in a penitentiary, state or federal, and he claims, as Mr. Gideon did, a violation of a fundamental constitutional right, we regard that letter to be an appeal. It may not be called an appeal by the prisoner, but we deem it to be an appeal. That letter is circulated, as Gideon's letter was circulated, to all of the justices. And so when Mr. Gideon's letter was received, it was put on a conference list, the list that we consider on Fridays when we go into conference. It was one of the first cases that I had an opportunity to consider after my appointment to the court. And when it came around, we talked about it at length, at as much length as we would about any case of importance. And we decided that perhaps we ought to consider again what the constitutional requirement of right of counsel really meant in a country that believed in equality.
Paul Clement, does the court still handle prisoners' appeals in the same way?
It still handles prisoners' appeal in a very similar way. I think that the Gideon case is one that for the law clerks stands out as the handwritten nature of the petition, and maybe is, when you're a law clerk and you're looking at petitions, particularly prisoners' petitions, the vast, vast majority of them are frivolous. But I think the very fact that Gideon's case was granted and is this landmark, I think is that sort of little voice for a lot of the law clerks that says, I have to take this really seriously because buried in here, there may be a very important claim.
And it was buried in the sense that Gideon sometimes is very crisp and clear, but other times in what he wrote, it's meandering, it's not so clear. But let me tell you that this, and if the law clerks are reading with great care, if they don't give up, if they're looking for the possible needle in the haystack, this is the essence of what Gideon wrote. The question is very simple. This is a quote. The question is very simple. I requested the court to appoint me attorney, and the court refused. Okay, now that's not probably just an attorney something, but it's very simple. I requested the court to appoint me attorney, and the court refused.
We're going to learn a little bit more about the Supreme Court that this case was heard by, but first let's take some of your phone calls. It's time for those. Beginning with a call from Josh in Algona, Iowa. You're on the air.
Good evening, you guys. My question is, how much of Justice Black's originalism or textualism had to do with the way he worded his majority opinion in Gideon?
Well, Hugo Black believed in the text of the Constitution. He was a liberal, but before there was Ed Meese, before there was Robert Bork, who taught me constitutional law, or Antonin Scalia, or Clarence Thomas, or Neil Gorsuch, all of whom say that they're kind of textualists and originalists. The original originalist in the 20th century was the great Hugo Lafayette Black. He always carried a copy of the Constitution, a pocket copy, with him. He comes from the Bible Belt, a fundamentalist part of the country where they take their sacred texts seriously in a Protestant tradition of reading their Bible. A critic would say, gee, you're stretching things because the right of counsel at the founding meant a right of retained counsel, counsel for someone who could afford it. And that's what a critic would say. One response is, as I said, yeah, but if you couldn't afford an attorney, the judge at the founding was supposed to actually help you defend yourself, but over time it became clear that you can't be an umpire and the ref and a coach, in effect, at the same time.
And I would say I don't think Gideon is Justice Black's most textual or originalist opinion. It is an opinion that's pretty concise and really relies more on the logical extension of the court's other cases, principally the Johnson case that you referenced about giving the right to counsel in the federal system.
And here's one other thing that the court really relies on that we haven't talked about. A really amazing case. I'm not sure C-SPAN has done it, the Scottsboro boy's case. But the Supreme Court in the 1930s had basically said, when you're on trial for your life, when it's a death case, you're entitled to appointed counsel. And part of what happened in Betts versus Brady, which was after the Scottsboro Boys case, was a racially charged case out of Alabama. And Betts said, oh, that's a capital case, but in all the other cases, we have to look at all the facts and circumstances. Sometimes you're entitled to a lawyer if if it's a particularly difficult legal case, or if you are feeble-minded, or if the prosecution has all sorts of resources. But we have to look at all the facts and circumstances. And what Black does say in this opinion is that's too complicated. That actually is too uncertain. As long as we're going to be in the business of requiring counsel when it comes to capital cases, why not just do it across the board?
Let me get a call from Peter in Elizabethtown, Pennsylvania. Hi, Peter.
Good evening. Can you hear me clearly?
Yes, we can.
All right. Thank you so much to everyone at C-SPAN, and especially these wonderful guests. Would you indulge me with give me like 30 seconds to say something in defense of C-SPAN? Very quickly. This is the second time I've been watching this program, and one of my more conservative brethren out there is criticizing C-SPAN, and I just want to say C-SPAN is fantastic. If you think C-SPAN is biased, sir, you're not watching enough, because the three channels do a marvelous job and have guests and programs that people on the right, the left, and front and center. I do not understand how anyone could criticize C-SPAN for having a liberal bias. All right, thank you for that. My question is to your wonderful guests. I would really like it if you could expand a little bit on what's the source of this idea of having a right to counsel when one is on trial, because I've always been taught and always been, I guess you'd say, brought up with the notion that ignorance of the law is no excuse. Just because you don't know what the law is doesn't give you any advantage in court or anywhere else for that matter. So why, where do we get this notion that once you become a defendant, then you have a right to someone to coach you along, to borrow the metaphor of a coach? I always thought that if I'm willing to testify the whole truth to the best of my knowledge, then the judge can, if I'm a defendant, the judge can look at the evidence and the court will decide what the correct assumption is. So
thank you.
Thank you so much.
Thanks for your call. Thanks for the kind words. What would you say to Peter?
Well, I would say to Peter that the right to have a counsel, the right to have a lawyer with you at trial, that comes right from the Constitution. That comes right from the Sixth Amendment in the federal system. I think the harder historical argument is to get from the right to have a counsel, if you can afford it, to the right to have the state provide the counsel for you if you can't afford it. And that's the leap that I think is less a leap that you make in history than a leap you make based on fundamental fairness and the way the system works. Because I think if you go back to even the first Justice Roberts' opinion in Betts that goes through the historical arguments, there's not a great historical tradition, at the framing anyways, for the state paying for a lawyer, the federal government paying for a lawyer. But the argument ends up being, look, the state itself, when they're trying to prosecute an individual, they pay for lawyers and they spend lots of money on it. And people of means, if they get accused of a crime, the first thing they do is go out and get the best possible lawyer that they can afford. And so is it really fair in our system to have somebody who can't afford to pay for counsel have to face this system where the deck is stacked, the prosecutors are paid lawyers and very highly trained lawyers, and anybody who could possibly afford it is going to go into court and have a lawyer? And so I think it's less an argument about history than an argument about the kind of fundamental fairness that is guaranteed by the Due Process Clause.
And the rules in court are very artificial rules. They're lawyerly rules. They're legalistic rules. At the time of the founding, there were maybe 6 common law crimes. Well, today, the statute books are really big and thick, and they're elaborate rules of evidence. So suppose you're innocent, but you don't know the right way to ask the question of, let's say, the prosecution witness. I'm not going to spoil the ending because we haven't told you really what happens in the Gideon case and upon retrial. But suppose, for example, you really do have a good defense, but you're a lay person. You don't know the rules of evidence. You don't know the rules of procedure. You don't know how to show the jury, actually, that maybe you didn't do it, that someone else did. And as Paul mentioned, the folks on the other side, the prosecution, this is a very accomplished legal team arrayed against you. They, for example, get to produce witnesses, subpoena witnesses against you. The Constitution says, well, to even things up, you should have a right to compel the production of witnesses in your favor. They can present evidence. You can present evidence. They can help pick the jury. You can help pick the jury. But none of that's going to work without a lawyer as a practical matter, because you don't know how to pick a jury, how to subpoena witnesses, how to compel the production of witnesses, how to cross-examine within the rules of evidence and all the rest. You need a lawyer for that.
Matt Smith asks on Twitter, did Mr. Gideon use the legal library of the prison to acquire the legal knowledge that spurred his letter? The answer is yes. He also had to follow prison rules, which is why he had to write it in pencil rather than pen. But my question for you is, are all state and federal prisons required to have law libraries, or do they do by practice?
They do by practice. I think many of them are required by their state laws, and I think if you had a jurisdiction that didn't provide it, there would be a due process challenge to it. So as a practical matter, you do have access to those kind of resources. And you have a lot of litigation that comes out of these prisons, so much so that Congress passed a law, the Prison Litigation Reform Act, to try to put some limits on it. So it is certainly a source of a lot of cases that continue to be filed in the courts and in the Supreme Court.
We're going to take 3 more calls and then back to our story. Charlene, Birmingham, Alabama. Hello, you're on the air. Welcome.
Hi, thank you for having me. I just wanted to know, I know that Gideon deals with criminal issues, but does the federal government actually allow a court-appointed attorney for civil if the person is indigent?
Thanks for the question, and good one.
In general, not. There are a couple of areas where people have made particularly strong arguments for a civil Gideon. That's what you're asking about. For example, if they're going to take away a child in a child custody case, there have been cases in the Supreme Court about whether that's so close to being put in prison yourself that you deserve a lawyer. If you want to declare bankruptcy and you're so indigent, you're so poor that you can't even, file the bankruptcy papers, do you have some right to government assistance in order to declare bankruptcy? And Paul will know some of the details of this, but as a general proposition, Gideon applies to criminal defendants in basically serious cases, basically felony cases, and it hasn't been fully extended to all traffic court cases or to civil lawsuits, whether you're talking about civil plaintiffs, people bringing the lawsuit, or civil defendants, folks who are being sued civilly. But Paul may want to give you some more details.
No, I mean, that's basically right. There are obviously programs that are available in a variety of jurisdictions to provide legal aid, to provide lawyers in civil cases. But in a sense, I think the current system for the civil system is a little like the criminal system before Gideon in that it's a piecemeal. You probably have a better chance in certain federal court cases than you might in a state court case. Certain jurisdictions have a much better developed legal aid system than other jurisdictions. So you're much more at the mercy of the particular jurisdiction you're involved in.
James in Caliente, California, you're on.
Thank you very much for taking the call. And again, thank you for the show and C-SPAN over the years. It just does wonderful work. Mike, first of all, I saw a crawl today on the news that Miss Brown of Brown versus Board of Education had passed away. And since you were talking about naming of cases earlier, I thought that was an interesting footnote. Regrettable, but inevitable. But my question is, in the systems that we have for legal assistance for criminal cases, I've heard over the years, I'm a retired attorney, I did not do criminal work, over the years people complaining that they simply weren't very good, or a lot of the public defenders were trying to get to be prosecutors. It didn't work as hard as they should have. I don't say this in a general sense. I have no idea. It's all anecdotal. But I'm wondering if a system maybe where attorneys were appointed and paid by the state, as opposed to a sort of established law firm, if you will, that just handles indigent defense, might be a better system, or some other system perhaps. Anyway, thank you very much.
Thanks for the question. So is it a right to competent counsel or a right to counsel?
Well, the Sixth Amendment does give you the right to effective counsel in the end. So, I mean, if you have somebody who's provided by the state who just does an absolutely abjectly awful job, you may have your constitutional rights violated in that way. But absent the sort of constitutional minimum, the reality is that the competence of state-provided counsel varies widely. I mean, frankly, the competence of privately paid counsel also varies pretty widely. But definitely the system, once it provides this right to a lawyer, there's lots of different ways to try to deliver those legal services in the best possible way. And I'm not sure that anybody has a monopoly on the best way to do that. I will say that in my experience, I have run across some incredibly talented public defenders providing very, very good legal advice to their clients.
I'm going to get a call from Jeff in Hickory, because I'm going to get behind in my story here. Jeff in Hickory, North Carolina, and then we'll go back to our story about Gideon. Jeff, you're on the air.
Thank you for taking my call, and also thank you. I've always wondered why, when the case was first went to the Supreme Court, it was Gideon versus Cochran, and then when the decision was handed down, it's Gideon versus Wainwright. So you guys answered that earlier. Thank you for that. But in studying this case and in teaching it to my students, I've always wondered, the Betts versus Brady precedent required that in special circumstances such as illiteracy or indigency, that counsel be appointed. And in the arguments in the Gideon case, it was evident that Florida had wantonly just basically ignored those special circumstances. Talk to me a little bit about why that was done so widely when it so obviously was against Supreme Court precedent.
That was one of Justice Black's arguments, and one of Abe Fortas, the Supreme Court lawyer for Gideon's big arguments, is the case-by-case approach in Betts was not working well. There was one absolute rule. In a capital case, a death penalty case, you got a lawyer. That's how Betts and some of the later cases came to read the Scottsboro Boy case, which I mentioned, out of Alabama. But then after that, it was all the individual facts and circumstances, and you're absolutely right. In, I think, 4 cases from Florida, the United States Supreme Court, each and every time, said the person on this set of facts is actually entitled to a lawyer, whereas the Florida Supreme Court had said they're not. So 2 courts, the Florida Supreme Court and the U.S. Supreme Court, purporting to basically follow the same set of principles in Betts versus Brady, but they keep disagreeing. The last time I think that the Supreme Court had ever upheld the someone who asked for counsel and didn't get it was 1950, and so Hugo Black and Abe Fortas, the lawyer for Gideon, the Supreme Court, Black, the justice, say, look, this case-by-case system isn't working very well, and in fact, it's worse for the states, because when we overrule a state decision several years after the trial, they're going to have to retry the person. Can you put Humpty Dumpty back together again? The witnesses have scattered. The physical evidence is scattered. Let's have a clean, bright line rule from the beginning in all serious cases. And now you're going to be aligned, serious cases as opposed to traffic court cases, but that's going to just be clean. We're not going to have to look at this defendant, that one, who was illiterate, who was underage, who was feeble-minded, whatever.
So the Supreme Court agrees to hear the case of Clarence Earl Gideon in the early part of 1963. Let's take a look at the 9 members of the Supreme Court who were destined to hear this case. We talked about the Chief Justice Earl Warren, and these are the other Eisenhower appointees on the court. John Marshall Harlan II. Some of our earlier cases were John Marshall Harlan I. William Brennan and Potter Stewart. Roosevelt appointee Democrat Hugo Black, whom we've been talking about, and William O. Douglas. Truman appointee Tom Clark, and Kennedy appointees Byron White, nicknamed Whizzer White, on the court, Arthur Goldberg, whom we saw in the earlier video, and he left in 1965 to be U.S. Ambassador to the United Nations. Is there anything else about the makeup of that court that we should know about as we go into this case? It was a unanimous decision, we'll remember.
Well, there's a lot we could say about the makeup of this court. One of the things that struck me is that compared to the current court, it's a relatively young court. The average age on the court of the 9 members is a little under 60 years. You have new members coming onto the court, as Justice Goldberg indicated in his video earlier. This is one of the first cases he's considering coming onto the court, replacing Justice Frankfurter, who was a big believer in federalism and judicial restraint, and may or may not have been a vote for Clarence Gideon. The other justice I would just highlight is the second Justice Harlan, I think, was one of the real proponents on this particular court of federalism and giving more respect for the states as opposed to imposing a one-size-fits-all solution. Just because we've applied a right in the federal context, we're going to apply it in the state context.
The oral argument was heard by the court on January 15th, 1963, one day of oral argument. And as we heard, Abe Fortas was empowered to represent Clarence Gideon, and Mr. Gideon was not in the courtroom at the time. He was still in his jail cell in Florida. We're going to hear next from Abe Fortas about why he wanted to take up this case.
I felt that the time had arrived when the court, with a proper case before it, would lay down the general rule applicable to all felony cases in the state courts, that every man, the rich, the poor, and the poor as well as the rich, was entitled to the benefit of counsel when he was defending himself against prosecution by the mighty forces of the state.
Akhil Amar, we heard from you both that Abe Fortas was a powerhouse lawyer in the federal court system, soon to be appointed to the court himself. It was a big deal that the court selected him to argue the case. Why did they do it?
Because they wanted to make sure that they were hearing the best arguments on both sides. My friend Paul has, I think, argued more cases before the Supreme Court than any living person currently in private practice, and if the court doesn't have, if one side doesn't have a lawyer, the court wants to make sure it's getting the best argument, they will pick someone like Paul Clement, someone like John Manning, the current dean of the Harvard Law School, to make sure that they're getting the best argument, which is part of the answer. And once you understand how important good lawyering is so that the judges can get it right, well, boy, that's true at trial, too, so that the jury can get it right. And we don't want people convicted just because they're poor. We want them convicted because they're guilty. And we can only be really sure of that if we have good lawyers on both sides. So actually, in a way, see, the appointment of Fortas himself kind of is proving the deep logic of basically Gideon's claim.
Arguing on behalf of the state of Florida was attorney Bruce Jacob. He was just a couple of years out of law school. We actually talked to him. He's in his 80s, and he sat down before our cameras and talked about the experience. We're going to listen to him explaining what it was like to argue this case before the court.
The day before the Gideon case was argued, Chief Justice Warren swore me in. And there were about 3 or 4 lawyers being sworn in. And I remember he's a huge man. He leaned way out over the bench. Of course, the bench in the Supreme Court is, just right almost next to the justices, just a few feet away. You feel like you're almost right on top of them. And he leaned out and he said, "Welcome to the bar of the Supreme Court, Mr. Jacob." Swore me in. I admire the Chief Justice so much. To have someone like that talk to me and use my name was really something. Something special. Before the argument and during the argument, it was pretty nerve-wracking to appear before the Supreme Court. They asked me at least 92 questions during the hour. Most of them were during the first half hour of my argument, so 92 interruptions. And quite often they weren't really interested in the answer. Instead, they were trying to make points with each other. After the arguments, I saw Abe Fortas again out in the hallway. I felt terrible. I just thought I'd done a really bad job because I was hammered by so many questions. Abe Fortas said to me, he said, you have a wonderful way before the court, which made me feel good because I thought I'd done really poorly, but he made that comment, really made me feel better.
Paul Clement, I saw you smile a few times as Bruce Jacob talked about his experience. You've been there so many times, but can you identify with this young lawyer, just a couple of years out of law school, being assigned this enormous case, being sworn into the bar? Tell us what you were thinking about when you heard him describe that.
Well, I was thinking it's almost ironic here because by the time this gets to the Supreme Court, in this trial court in Florida, the deck is totally stacked against poor Clarence Gideon. By the time to get to the Supreme Court, it's almost the exact opposite. Because here's this lawyer from Florida who's fresh in the prosecutor's office, and he's getting sworn in the day before his argument. I think I read in Anthony Lewis's book that the day before was the first time he'd ever seen Supreme Court argument, and he's arrayed against Abe Fortas, who's a leading member of the bar, who was essentially handpicked by the court to argue this case, with the court knowing even at the point that they were appointing Fortas that they probably had at least 5 votes to overrule Betts. So it's really a stacked deck against this lawyer who's making his maiden Supreme Court argument, which is incredibly nerve-wracking under the best of circumstances, and he's facing some pretty tough circumstances. I also couldn't help but think that was an awfully nice thing for Abe Fortas to say after the argument.
91 questions he said he was peppered with. He knew the exact number. So is that common for people who are arguing cases before the court?
Well, as Paul will tell you, and he really is the expert here, we might, in recent memory, distinguish between, just like there's, BC and AD, pre-Scalia and post-Scalia. That before Justice Scalia, in general, the bench was a little bit cooler and more quiet. Literally from his very first day on the Supreme Court, Justice Scalia actually began to change all of that, and now most of the justices lean in a very big way. I was told the story that in Justice Scalia's very first day on the, so it's now a hot bench, and it wasn't as much before. Paul can confirm this if it's true or clarify it, but the story is told, at least, that on that very first day of Justice Scalia on the bench, and he's asking question after question after question, one of the justices, a very polite, courtly Lewis Powell, leans over to Thurgood Marshall, who sat next to him, and says, "Do you think he knows we're here?" So that's a story that I've heard.
You had made the case that the court wanted to hear the best arguments on both sides. Joe Paulson tweets, if they wanted to hear the best arguments on both sides, they needed someone more than a 20-something junior on the state side.
Although remember, that's Florida's call. The sovereign state of Florida, with all its vast resources, could have picked anyone it wanted for that. And so it is a bit of a problem that Florida maybe, they could have sent a whole team of lawyers if they'd wanted to.
Are you both, I don't want to put you on the spot, can you encapsulate the arguments very briefly made by each side in the case?
Well, I mean, I'll try. I mean, I'll try with the Fortas side. If you want to try with the state side, I mean, Fortas knows that he's in a position of strength, so he needs to do a couple of things. One thing is he needs to make clear to the court that this is the right case to overrule Betts against Brady, and he's in an odd position here because the Supreme Court doctrine says that if there are special circumstances, special disabilities for the defendant, then you're entitled to counsel even under the Betts rule. So in an odd way, Fortas has to a little bit argue against his own interests by saying Clarence Gideon's not that special and actually didn't do a terrible job. He did the best job that you could expect a layperson to do. So he has to establish that there aren't special circumstances here, because otherwise the court doesn't have a need to overrule Betts v. Brady. And then his main mission, I think, is to get the court, all of the justices, comfortable with the idea that they can do this consistent with federalism and consistent with their jurisprudence about how the Due Process Clause and the Bill of Rights applies to the states. And it's a trick, and this is very much the case with the current court in other areas. But you're not arguing to a monolith. You're arguing to Justice Black and Justice Douglas, who have a very distinct view of how incorporation works. And you're arguing to Justice Harlan, who's much more skeptical of applying the federal Bill of Rights to the states. And you're trying to pull it all off at once. And I think the key, and the professor alluded to this earlier, but the key was that Fortas decided that he was going to argue that the current doctrine, special circumstances, the court overruling states on a case-by-case basis, was actually worse for federalism than a nice, clean, bright-line federal rule.
Florida's case.
Maybe in 3 words: precedent, federalism, and floodgates. Precedent. Betts versus Brady is the Supreme Court precedent. And why shouldn't we just follow it the way we ordinarily follow precedent? States' rights, yes, a clean, bright line rule might be better, but Florida could have chosen, if it wanted to just as a matter of kind of prophylactic, to provide everyone a lawyer. They decided not to, and aren't they the best determiner of what's in the interest of Florida? Floodgates. There are a lot of people who are already in the prisons right now, and they didn't have lawyers And are you now going to have to let them all out or attempt to retry them, but many years later the witnesses have disappeared, the physical evidence has evaporated? Is that what you want to do? Do you want to, of the 8,000 or 10,000 people in Florida, I think half of them had been convicted without appointed counsel? That's a practical argument that the court has to consider.
In addition to the arguments made before the court, Akhil Amar mentioned earlier that 22 states had filed amicus briefs, that's friend of the court briefs, in support of Gideon, and 2 had submitted briefs supporting the arguments of Florida. Can you talk about the role of these amicus briefs?
Well, amicus briefs are generally briefs that are filed sometimes by state governments, sometimes by the ACLU or other private groups that are offering the court their own perspectives on the issue. And they can be somewhat influential in a lot of cases, but this particular dynamic where, poor Florida, they're trying to argue for states' rights, and roughly half the states in the union are on the other side of the case. And so that state amicus brief, I think, carried much more weight than an ordinary amicus brief, because it's sort of a Nixon goes to China kind of amicus brief. It's a bunch of states arguing that they actually want a federal right that forces them, even if the ones that already provided it under the current system, they could change their mind. But they want to be told that the federal Constitution compels them to provide appointed counsel. And I have to think that not just the fact that there were a couple of states on that brief, but that the fact that there were 22 or 23. I think New Jersey wanted to join the brief after it was filed. So 22 or 23 states are against Florida. That's remarkable.
It's the final compelling paragraph of Justice Black's opinion for the court mentioning that fact of the amicus briefs.
Our phone lines are open. We've got time now for a couple more calls, and then we'll get to the decision. It was rendered on March 18th, 1963, a mere 2 months after the court heard the oral argument. And before we get to some of the text of that decision, let's hear from Chris in Hermiston, Oregon. Thanks for waiting, Chris. You're on the air.
Hey, how are you doing tonight?
We're doing just great. What's your question for us?
Great. I just had a comment more on the question. I just wanted to say that I didn't realize the time frame of this, that, I don't know exactly when the law was passed that defendants were given, the right to have counsel. And I just wanted to say that I spent 20 years in the military, and one of my soldiers was brought in front of a court-martial. And I didn't know, by talking to the defense attorney, that until the mid-'80s, that soldiers who were in front of a judge weren't provided actual counsel in the way of an attorney. Military officers in the unit were appointed to be their defense counsel. So I thought it was an amazing fact that, the government gets the prosecutor on their side, who is an actual attorney, and then to turn around and say, oh, by the way, you armor officer, you artillery officer, you now have the secondary job of providing defense for this soldier. I mean, this soldier that my guy had gone through, he had counsel, but I just thought it was funny that almost 20 years after Gideon versus Wainwright, that, soldiers who, joined the military, there wasn't a draft anymore, they joined the military, and they still, 20 years later, aren't provided counsel in that aspect. There's somebody who's not a trained attorney. And also another choice that I didn't know if anybody really knows this, that a soldier has to make is, do they have a trial by their peers, so a jury of their peers, or is it just the judge making the decision? So there throws another dynamic into it, that an officer looking at, and my soldier had to stand in front of a colonel. You have an officer standing in front of a colonel trying to make a defense argument who is not trained to be an attorney. So I just wanted to kind of bring that up and just provide that information.
Thanks very much. Any comments on the civil system versus military?
Military justice has always been a world apart. The Fifth Amendment to the Constitution says one interesting thing. No person shall be held to answer for a capital, that's a death penalty, or otherwise infamous crime unless on presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia, And so there's special rules. You don't generally have a grand jury in the military system. You don't always have a trial jury, as Chris mentioned, in the military system. The judge in every other federal proceeding is someone who has life tenure. That's not always true in the military system, where actually the judge is a military officer who was in the Article II executive branch chain of command. So military justice has always been a distinctive domain.
A question from Wild and Wonderful on Twitter. Did Gideon know to preserve the right to counsel issue in trial court, or was his doing it simply dumb luck? Does the fact that he brought a habeas but not an appeal suggest one or the other?
I'm not sure that the ultimate form that he sought relief suggests one way or another. I mean, I think he actually did a pretty good job of lawyering the case from prison. I think, in a sense, and I'm just guessing here, that his insistence on a lawyer and the fact that he was so insistent that the Supreme Court gave him a right to a lawyer, even though, as the professor indicated, he was wrong about that, I think that just flowed from just an innate sense of justice, that of course he was entitled to a lawyer. I don't know if he'd ever, read bets or thought I don't think so. I think he just thought, of course I'm entitled to a lawyer. The prosecutor sure has a lawyer.
Steve in Cape Girardeau, Missouri. What's your question for us?
Hi. The state of Missouri has been serious budget problems, so they've had to cut back on the number of public defenders, and public defenders are overworked. So what they've done is set up a whole series of cases or charges where you can only face a fine, and therefore you're not entitled to a lawyer. Well, even though it's only a fine, you go to court, you're facing the entire power and weight of the state government against you with the prosecutor. How does Gideon affect those cases?
So one issue that Abe Fortas has to decide is he going to just try to win the case for the client to whom he's been assigned, Clarence Earl Gideon, or is he going to have to want to establish some even broader principle? Is this a right that for only serious criminal cases, or does it even apply to traffic court? And as we heard in an earlier question, should it apply to civil cases? At the end of the day, he has a duty, an obligation to his client, and he offers the court the narrower option, saying, well, all you need to decide today in order for my client to win is to say, in all serious cases, not just death penalty capital cases, but all, in effect, felonies, and that's all the Gideon court really does decide. Later cases, Justice Black's opinion is not entirely clear on just how broad or narrow this right of counsel is. He says it applies in state cases, not just federal, and we're not going to look at all the facts and circumstances, Betts versus Brady, but only later cases clearly establish the line basically is the felony line.
Yeah, and if I could just add one thing about Fortas's dynamic or his situation, he really does have a very interesting dynamic in terms of his loyalty to his client here, because he knows he's being appointed to argue the case to overrule Betts v. Brady, but he has an obligation to his client to win the case on any ground. And so one of the things he does when he gets first assigned the case is to search for the special circumstances that might allow him to win the case even under Betts v. Brady. And I was really struck by that as a great example of the lawyer's obligation to the client. I mean, Fortas kind of knows that if he finds special circumstances, this won't be a landmark case. Right. But he's got to look for him anyways in order to satisfy his obligation to his client.
Sean, Vienna, Virginia, you're up. Go ahead.
Thanks for having me. Yeah, I have a quick question. And it's basically, is there an example of a conviction that was overturned after this decision was rendered because it was determined that the defendant wasn't given adequate counsel? And I'll hang up and hear your answer off the air. Thank you.
Sure. The principle that this case establishes applies not just to Clarence Earl Gideon, but to all sorts of other people, all the cases that were on appeal at the same time, and later cases are actually going to say, oh, it applies, even more broadly than that to all sorts of people whose convictions had been final, but they didn't have, when Gideon was decided, but they didn't have proper lawyers. It's also going to have some implications whenever someone is prosecuted for some crime committed years after Gideon, and the claim is they're sentenced and they're convicted and they even have a lawyer. But the question is whether their sentences should ever be enhanced because of an earlier conviction that they had that was without the benefit of counsel.
So we learned that the decision came down on March 18th, 1863. 1963, thank you, and that it was unanimous. And Hugo Black authored the unanimous decision. And here's an excerpt of what he wrote. Even the intelligent and educated layman has small and sometimes no skill in the science of law. Left without the aid of counsel, he may be put on trial without a proper charge and convicted upon incompetent evidence or evidence irrelevant to the issue or otherwise inadmissible. He lacks both the skill and knowledge adequately to prepare his defense. He faces the danger of conviction because he does not know how to establish his innocence. 22 states, as friends of the court, argue that Betts was an anachronism when handed down. It should now be overruled. We agree. 3 justices, even though it was unanimous, wrote separately to express their agreement. They were Tom Clark, John Marshall Harlan II, and William O. Douglas. These are called concurrences. Why did they take the time to do that?
Well, they all had their reasons to write separately. I think for Justice Clark, it was, for him, the real reason is that the court had already extended the right to capital cases, and he didn't see a difference between capital cases and non-capital cases because the due process protects your life and your liberty. For Justice Douglas, it was a very specific reason. As I alluded to earlier, he and Justice Black had a unique approach to the incorporation of the Bill of Rights, and it's a little bit of an irony here that Justice Black, who has this distinctive view, because he's assigned the majority opinion, can't really fully embrace that in the majority opinion. So Justice Douglas basically does it for him in a concurring opinion. But then Justice Harlan's opinion in some respects is, I think, the most interesting, and his vote in the majority is maybe the most surprising. And he has a line in his concurrence to the effect that, the court is dealing with the Betts case. He thinks that the Betts case, although it should be overruled, deserves a more proper burial. And it's really that last line that you read where Justice Black concludes for the court that basically Betts was wrong the day it was decided. Justice Harlan won't go that far, in part because he was on the court. But he says that essentially experience has shown that as a federalism matter, this doesn't work. He also writes to distance himself from the Douglas view of incorporation. So you really get a sense in those opinions, of those separate opinions, although they're all short, you do get a sense of some of the underlying currents in the Warren court at that time.
This is a case, of course, about Clarence Earl Gideon, but it's such sweet vindication for Hugo Black, you see, because he dissented in Betts, and now he has a court majority, and he can't quite resist. It's a very natural human tendency to say, I told you so. I was right all along. And yes, Justice Harlan can't quite go along with that. But Hugo Black, this is vindication for a view that he had been putting forth forever.
Next, we're going to listen to Clarence Gideon and the attorney for Florida, Bruce Jacob, talk about the reaction to the Supreme Court's decision.
Well, I felt great because I was listening for the decision on the radio. When it came on, most of the prison population heard it. You could hear them holler for 10 miles, I suppose, from there. And I also received a telegram from Mr. Fortress congratulating me on the decision.
Phone call from Anthony Lewis. He was the reporter for the New York Times at the Supreme Court. He was allowed to sit within the bar. Anyway, he promised me that when the opinion came down, since he was right in the court, he would immediately call me and would tell me what the result was. I was a little bit disappointed that the decision was unanimous. I was hoping there may be at least one Justice Harlan, a couple of other justices who at least we thought might vote on our side.
And in fact, the country was waiting for this decision. We have a New York Times front page article, Supreme Court extends ruling on free counsel. What was the reaction nationally to this in the media and in the legal circles?
Well, I think the reaction was very positive to this decision. I think the fact that it was unanimous was an important component of that. I think if the court had come out the same way, 5-4, I'm not sure the decision would have had quite the effect that it did. And the effect went beyond just the narrow circumstances of the case, because we've alluded to the fact that there was counsel provided in the federal system, but it wasn't always provided that well. It wasn't provided that systematically. And the Gideon case really was sort of a watershed development in terms of not just extending the right to the states, but also really reforming the system more generally so that counsel was available in, an experienced and adequate counsel in many more places in the country than it had been before the decision.
We heard that Florida had concerned, the floodgate argument that they had more than 1,000 prisoners in Florida prisons who had stood trial without counsel, and they were worried about having to retrial those cases. Next up, we're going to hear Louis Wainwright, the person whose name is the namesake for this case, who was the head of the Florida prisons from 1962 to 1987, talk about the impact of this decision on his state.
We have had a total of about 5,300 motions, petitions for relief filed as a result of this decision. And of course, we have had over 1,000 that have been totally released as a result of it.
And many people are afraid that all these, well, over 1,000 men have been released, they'll just go right out and commit crimes again.
Yes, that's been a concern of those in law enforcement and the officials of our state. However, we have not found that that has been the case, because out of the over 1,000 that has been released, we've only had about 4% that have returned with a new conviction so far as we know.
And how does that compare to the national average?
Well, actually, the national average is about 65%. 65% of our population are repeaters. And about 20% of those released on parole fail to make it and return to prison.
You're going to set aside a part of this prison and call it the Clarence Earl Gideon Memorial Hall?
No, sir, I don't believe that we'll go that far, but he'll be remembered here a long time, I'm sure.
Anything to make of the low recidivism?
I think it's just a stunning fact. And I mean, there's no reason to think that there's something about these 1,000 people that, that somehow they were uniquely unlikely to be recidivists if they were in fact guilty of the underlying crime. So I don't think you can listen to those remarkable statistics. I mean, 4% versus 65%, and not think that a lot of those 1,000 people that were released were probably innocent of the underlying crime.
Which is just what Hugo Black said in that wonderful quote that you offer, Susan, that the problem is that people are maybe being convicted just because they're poor rather than guilty.
So earlier you told us that Gideon had argued habeas corpus, and in fact in this book, Gideon's Trumpet by Anthony Lewis, we learned that he was frustrated by the Supreme Court's decision because he thought if they ruled in his favor, he'd be let out of jail. What actually happened to him?
Because he wasn't a lawyer, and it's not double jeopardy to retry someone who was actually convicted the first time. If you set aside the conviction, doesn't mean the game is over. It just means you retry, you play the game, you do the game again. So he thought he was absolutely done, and he was not at all pleased when he was repeatedly informed by lawyers, no, there's going to have to be a new trial. And eventually there is a new trial, and I hope we're going to talk about that.
We are. In fact, Fred Turner was the lawyer who represented him in his second trial. And we're going to listen to Clarence Gideon now talking about his legal fortunes and having a lawyer represent him, and here's what happened to him.
So we go to trial, exactly 2 years and 1 day from the first trial. We go in the same witnesses, the same courtroom, the same judge, the same kind of a jury, and through Mr. Turner's efforts. And the evidence was so simple that it had been impossible for me to committed the crime.
On August 5th, 1963, a new 6-man jury found Clarence Earl Gideon not guilty.
I think him winning that acquittal was the most important thing in this whole case. It showed the difference, definitely, between not having an attorney and dealing with an attorney.
Paul Clement and Akhil Amar, your reaction to hearing him say that. Paul Clement first.
Well, I mean, this story and this case wouldn't be the same if he were convicted again on the retrial. I mean, this just dramatically shows the difference a lawyer can make. And, you know, if you get into sort of the details of how the retrial took place, I mean, his lawyer was really able to pin down the government's key witness and point out to the jury his prior criminal history and criminal activities and bring that star witness for the prosecution, put him in a dramatically different light, suggests that he was actually involved in the crime himself and was serving as the lookout for the perpetrators of the crime as opposed to this innocent, eyewitness. He was able to point out that basically given the phone booth he was at and where he was looking, he probably couldn't have even seen into the pool hall. There were all these things in the government's case that looked so different when you had a lawyer there who was able to very effectively cross-examine the star witness and then make a closing argument that brought it all together for the jury.
So this is a perfect illustration of the point that the courtroom is governed by these very technical rules of evidence. The star witness against him, Gideon asked him, "Have you ever been arrested?" And that was objected to. But the lawyer was able to bring out, have you ever been convicted? And the fellow said, well, not quite. And it was, there was probation, blah, blah, blah. So the lawyer knew how to navigate the rules of evidence in a way that Gideon didn't.
So the impact of this decision for criminal defendants, how did it affect the system? In fact, let me just use a tweet to ask that. How did Gideon v. Wainwright case affect the criminal justice system with regard to the Sixth Amendment right to a speedy trial? So what happened more systemically?
Well, systemically, what happens is that this right now becomes a nationwide right. It is the Gideon case is a impetus for reforms in the federal system, providing appointed counsel and creating the financial sort of structure so that somebody can actually provide this service and make a living as a lawyer and become expert in providing criminal law. You have public defenders' offices that are essentially put in place after this decision. There's an interesting way, too, that this Gideon decision is related to the rest of the Warren Court's revolution in criminal procedure, because the Warren Court is giving criminals new rights, but they're complicated new rights that you'd really need a lawyer to take advantage of. So it's not clear to me that you could have had the rest of the Warren Court criminal procedure revolution if you didn't have Gideon in place.
There are two kinds of fundamental rights that really are best understood as the rights to have rights. In the real world, basically, if you can't vote, then you're not able to protect yourself. The right to vote is preservative of all other rights. It's the right to have rights. That's in the real world. In the special artificial rule of a courtroom, which is governed by rules of evidence and procedure and all sorts of legal technicalities, a lawyer is the right to have rights. And without a lawyer, none of your other rights are really particularly meaningful. Just like in the real world, unless you can actually back something up with a right to vote, politicians aren't going to pay much attention to what you think. So we see lots of people out there right now taking to the streets for this cause or that one. And I say to people on both sides, you can't just march, you have to vote. Because if you don't vote, actually you're not going to be heard. And in courtroom, you have to have a lawyer because otherwise you won't be heard.
We actually dealt with the Warren Court's 2 other decisions that are part of this framework in our first season of landmark cases, Mapp v. Ohio in 1961, Miranda versus Arizona in 1966. They are on C-SPAN's website under the Landmark Cases tab. You can see it there. You can also order our Landmark Cases companion volume written by Tony Morrow, who is a longtime Supreme Court reporter that can give you all of the framework for these cases as we work our way through the 12 on that website. And while I'm saying thanks and giving you background, a special thanks to the National Constitution Center led by Jeff Rosen. They've been our partners in this series for Season 1 and Season 2 with helping us select the cases and helping us book our guests for the program. So a special thanks to them. So this case has been depicted, as we saw in the Anthony Lewis book. It was also a movie that was made by the same name, Gideon's Trumpet. Why do you think the popular media was so intrigued by this case?
Well, it is this, and I think Paul is right. If he doesn't get acquitted in the second trial, you just see the difference between having a lawyer or not, and maybe someone else really did do it. At the very least, there's reasonable doubt. And he wasn't, he's an intelligent person, but he's a lay person. He's not trained. He wasn't able to tell his story the right way in court in a way that 6 jurors could understand. So, but with that outcome, the different outcome the second time around, it is made for Hollywood. And just to remind the audience, it could have been someone else. The Supreme Court was looking for a vehicle to do this, and it could have been another person who was guilty as all get out, and the retrial wouldn't have made a difference. And then maybe it doesn't feel quite the same way, at least for Hollywood purposes.
But in any of these cases, it's the David versus Goliath story, isn't it?
It is. The 2 components I think that made this so great for television is the result of the retrial and the fact that petition, that letter to the court was handwritten. Mm-hmm. I think if he's not, if he's convicted on retrial, it doesn't make it to the Hallmark series. And if he types the petition, I'm not sure it has the same resonance with people. But everybody has some innate sense that you can take your case all the way to the Supreme Court. And as someone as meek and humble as Clarence Gideon can take his case to the Supreme Court by writing out his petition in pencil on a piece of paper, I mean, it really does show that anybody can take their case all the way to the Supreme Court.
And he was no choir boy. Let's just remind the audience that he had, 4 prior felony convictions?
Yeah, he'd spent 17 years in jail prior to this.
In Missouri, in Texas, now this is Florida, in the federal system. So, and that's been true. It's true for some of the other landmark cases that some of the litigants are, characters.
And that's why we like this series. Next is a call from Marco, Livonia, Michigan. You're on the air.
Thank you. You've already answered my question about the public response to the case, but maybe you could shed some light on what ultimately happened to Abe Fortas. Why was he rejected as Chief Justice when he was nominated by Johnson?
Paul Clement?
Thank you.
No?
There were some allegations of financial impropriety and Paul and I both commended lawyer Fortas's legal ethics in this case, representing his client's interests rather than just trying to make a name for himself in a landmark case. He is eventually nominated to replace none other than Earl Warren. He was going to be elevated. He was already on the Supreme Court as an associate justice. He was nominated to move up to the Chief Justice position, and in the course of that nomination process, a second vetting occurred, and allegations of financial impropriety arose about taking money that he shouldn't have in various contexts.
A viewer on Twitter asked whether or not his representation of Gideon before the Supreme Court influenced the decision to appoint him to the court in the first place.
Well, I don't know that it hurt, but I don't think it was the critical thing. I think some of the same characteristics of his practice that recommended him to the court as the appointee for this particular landmark case, also would have recommended him to the president as somebody who could sit on the Supreme Court.
Next is a call from Greg in Dayton. Hi, you're on.
Hi. Thank you for taking my call. I've got a question about these landmark cases. My wife and I have been in the state and federal courts for the last 18 years on matters of insurance company fraud. And we made an original instant action for a jury demand in this trial. And for 18 years now, we have not had our due process under the 5th or 14th Amendment to uphold the 7th Amendment to this right to a jury trial. And I don't know if your guest can make a comment on that. And how do the American citizens get their day in court as a pro se litigant where attorneys have turned their backs on the Constitution, as well as our state and federal politicians and judges, and even your guest here who has had our case before him, Paul Clement? Why do we not have our day in court against insurance companies, and how do we get it? Thank you.
Well, you know, one of the backdrops for this case that we've alluded to is the debate over the incorporation of the Due Process Clause. And Justice Black and Justice Douglas were the foremost proponents of total incorporation. So every provision of the Bill of Rights would be applicable to the states. But although they argued for that position year after year, it didn't ultimately carry the day in the Supreme Court of the United States. So what we have is a process where some of the Bill of Rights apply to the states, and some others of the Bill of Rights don't apply to the states. And the Seventh Amendment jury trial is one of those provisions that hasn't been incorporated against the states. So I think that's at least part of the answer to why a Seventh Amendment argument in the state court system is likely to be ineffective.
We're running out of time pretty quickly here. Let's use our last piece of video, and it's Clarence Earl Gideon once again. He is asked about what his legacy is and how he should be remembered.
Did you have any feelings about having made history in your case? Have you ever felt like a historical figure?
No, that wasn't nothing brilliant that I'd done. It was just I was fortunate enough to have a case and come along at a time that the United States Supreme Court wanted to. The majority, in fact, it was unanimous. They wanted to redo this decision and make it possible that everybody in the United States should have a legal counsel.
Clarence Gideon reflecting on the role that he played in this landmark decision which changed American jurisprudence. We have about a minute left. I'm going to ask each of you, starting with Paul Clement and then with Akhil Amar, what should people take away from our discussion tonight about the importance of this case?
Well, the right to counsel is fundamental, and I guess I just can't help but note that when you listen to Clarence Gideon, it is remarkable how much self-knowledge and humility he has about the role that he played, because he did play an important role by preserving this argument and bringing it all the way to the Supreme Court. But even he seems to recognize, quite remarkably, that the court was ready to do this, and he was, in some respects, very fortunate to have the right case at the right time.
And as much progress as Gideon embodies, it can be asked whether we've really done full justice to the deep ideas, whether we're providing enough resources in the criminal domain to make Gideon a full reality. There are folks who say we should have gone beyond felony cases to misdemeanor cases, to traffic court cases. You heard questions about civil Gideon for indigents in various contexts. And you heard questions today about civil juries in general, and what there are lawyers who lament the vanishing jury trial, both state and federal. Lots of things are pleaded out in the criminal system, and they never get to trial. Definitely don't get to jury trial. The civil system. One entity that really is championing civil juries in a very interesting way. It's a project at NYU Law School organized by a very great lawyer named Steve Sussman, and you won't be surprised to know that way back when he was a law clerk to none other than the great jury trial lawyer Hugo Black.
Well, thanks very much to Yale Law School professor and constitutional expert Akhil Reed Amar, and to former U.S. Solicitor General Paul Clement for being back on Landmark Cases this season. So glad to have you. And thanks to all of you for watching, and for those of you who sent in your questions, for participating.